he didn't come in as an expert in the sense of an expert. He was an expert who was experienced in the system in itself, because it's such a specialist system. He was instructed as an expert.
I'm sorry?
He was not instructed as an expert. He came in as a witness of fact.
I think your answer is no. Because I didn't think he was an expert.
No, he wasn't considered as an expert.
Yeah. No, hold on, I haven't asked the question yet.
Well, that's where you're coming. Well, okay, ask the question.
Just wait and see.
Okay, all right.
Is the fact that you were attending a consultation or conference with counsel with Mr. Jenkins a couple of weeks before trial an indication that, in fact, you treated him as an expert? Pretty unusual to sit down with prosecution counsel and chat through a witness of facts evidence, isn't it? Did you feel confused at the time?
So we're going to jump back into Jarnail Singh's testimony here at the Post Office inquiry. And the one question we're asking ourselves is, when is an expert witness not an expert witness? Jarnail Singh goes on to describe that Horizon's a very specialist system and there's only one person that knows the answers, Gareth Jenkins, but insists that he's not an expert. Or is he an expert? Well, he didn't meet the requirements of an expert witness's report, so guess he wasn't an expert. Or I actually had a meeting with him just like I would an expert. Should we try and clear this up? Let's jump into the inquiry.
And before embarking on the detailed evidence, can we agree on the following? Firstly, in the case of Seema Misra, no witness statement relied upon by the Post Office from Mr. Jenkins included any of the necessary inclusions required by the common law and the criminal procedure rules that I've just listed.
No, because he didn't come in as an expert in the sense of an expert. He was an expert who was experienced in the system in itself, because it's such a specialist system, and he assisting the prosecution, the defense, and the court into understanding how the system worked, or the operation of the system.
So there was a very specialist system that no other expert could comment on, so we got somebody from Fujitsu who knew the system inside out, presumably, and we didn't call him an expert, but we treated him like an expert, but the evidence he provided to court was definitely not expert. Really?
I think that's why and how he came into advising. He came in as somebody who knew the system well.
So I think you'd agree that none of the witness statements supplied by
because he didn't.
Mr. Jenkins and relied upon by the Post Office in the case against Mrs. Misra included any of the necessary elements that I have just listed.
Yeah, purely because he was instructed as an expert.
I'm sorry?
He was not instructed as an expert.
I think, as a matter of generality, before we come to the detail, you would therefore agree that you did not provide Mr. Jenkins with any instructions as to the duties of an expert?
No.
You did not provide Mr. Jenkins with any instructions as to the need to document, for example, the work carried out by him and by others, which formed any part of the evidence that he was to give?
No, purely because he came in as a witness of fact. He was put forward or recommended by the Fujitsu as the best person who can answer or advise the prosecution and in turn the defence. And I think all he did was to the questions posed by the defence expert to assist him to understand the system.
So he's not an expert, but he's the best person to answer an actual expert's questions on the system, and he's definitely not an expert of Horizon, the system that the company that employs him has developed. We couldn't find anybody else with the capabilities to comment on Horizon because it was so sophisticated, yet this guy, Gareth Jenkins, who definitely isn't an expert, could supply answers to the questions and be a witness of fact. Sounds like you're putting him forward as an expert.
I think it follows that you did not provide Mr. Jenkins with any sort of document or schedule upon which he should record, for example, the material that he had considered in order to form his expert view.
I don't know what material I'm supposed to provide. It's like the way the whole he came into being was purely whatever information we had from the defence expert, and he was basically forwarding it on to him to respond to it like any other witness. I didn't take any witness statement from him, and I don't think I've actually physically met him until from the documents and the inquiry has provided me with. I think the first time was probably in a conference around about October, and I think 2 or 3 weeks prior to the actual trial. The normal practice of the post office was not the solicitor to take a witness statement, but to the investigation officer to do so. And that's how it worked out. Certainly the defence solicitors would send their inquiries, and I think maybe once they've put forward the challenge to the Horizon system, they instructed their expert.
Surely it would have to be the solicitor who's taking the statement, because surely they're the only ones who potentially know the actual requirements of the witness, in terms of credibility, admissibility of evidence. The investigators have already said that they weren't really trained an awful lot. So is it really the situation where virtually untrained investigators were expected to take witness statements which would be relied upon in court?
They in turn put forward these reports plus further inquiries that went to the investigation officer. He in turn that this information needed to be dealt with by Fujitsu, and I think there was in place some sort of procedure, system or process in place that needed to be followed, and I think because of the time constraints or we needed to respond within a certain period of time, that's when I got in touch with the Prosecution Support Office, Fujitsu's Prosecution Support Office, and they said, no, you've got to follow certain procedures which would be time consuming. And just to escalate the matters, I was given a phone number for the head of legal at Fujitsu, who I contacted, and he recommended Mr. Jenkins. That's how he came into being.
Mr. Singh, can I cut through this?
So is that a way of cutting corners? I don't know. If you've got procedures to follow and you're saying you've not got enough time to follow them, then presumably the only way you can speed that up is by cutting corners. Oh, here's some dude who can talk to you, but he's not an expert.
Asking you at the moment whether you provided instructions, reminders to Mr. Jenkins of duties that I've outlined, instructions as to the need to document work carried out by him or by others that was going to form a part of his evidence, and with a schedule or work record detailed the material that he had considered as part of his work. And I think your answer is no. Because I didn't think he was an expert.
No. Well, I don't know. But I think you followed it up, and you presumably wanted me to elaborate. But yes, no, that's right. You're right.
And I think it follows that there's no documentary.
No, because we didn't have any documents at that time. What documents could we have provided? So I didn't have any documents.
I think you're misunderstanding me. I'm asking whether you approached Mr. Jenkins on the basis that he was an expert and then said to him, look, Mr. Jenkins, as you're going to be giving expert evidence, it's necessary for you to record in order that we, the prosecution, can disclose the work that you carry out in order to form your expert view, including a record of who you spoke to and communications that you received from others, insofar as they end up being part of your report.
At that stage, no. At that stage, he wasn't considered as an expert. He was just more or less responding to the experts' report or their inquiries or their questions, if you like, because he was he was put forward as the person who could deal with them.
So you think then, okay, we'll take what you say at face value. You think the best person to respond to an actual expert's questions about something is someone that you don't consider to be an expert?
He was he was like any other witness we would have in court to give evidence.
And do you have conferences with any other witness? Do you sit down with witnesses of fact and discuss their evidence with them? Before a couple of weeks before trial, in a barrister's chambers?
Well, we didn't have any trials. I mean, certainly
Sorry? No, I'm talking about Seema Misra. You've told us that you attended a conference with counsel Warwick Tatford in October 2010, and Mr. Jenkins was present, which you mentioned earlier.
Yes.
Was it usual for you to sit down with witnesses of fact and chat through their evidence with them?
I think it depended very much on the case.
So you would sometimes chat through a witness's evidence with them in a prosecution?
I think with some of the areas certainly we did, in the sense that try to understand the actual system or the technical aspect of it. I think I don't know. Maybe it's I can't. I mean.
I'm not so sure you needed to understand the technical aspects of the system. I think you needed to understand the evidence that they were actually proposing on, swearing an oath to in court as a non-expert, knowledgeable person.
I think I'm sure we have.
Presumably you want to keep a pretty careful record if you were chatting through the evidence of a witness of fact a couple of weeks before trial, wouldn't you?
No, well, certainly, but I mean, certainly the investigation officers. I can't recall exactly whether where we were, how we dealt with it now, but certainly I always had my notepad with me.
Or is the fact that you met Mr. Jenkins in consultation with counsel a couple of weeks?
Well, I haven't taken any papers with me from the post office when I left. Everything's there.
No, hold on. No, I haven't asked the question yet.
Well, that's where you're coming. Well, okay, ask the question.
Just wait and see.
Okay, all right. Yeah.
Is the fact that you were attending a consultation or conference with counsel with Mr. Jenkins a couple of weeks before trial an indication that, in fact, you treated him as an expert witness? Because that's what one might do with an expert witness. Rather than a witness of fact. Pretty unusual to sit down with prosecution counsel and chat through a witness of fact's evidence, isn't it?
I can't really tell you how these came about. I think certainly counsel asked for a conference, and I think originally I didn't. I mean, it was such a long time ago. I didn't actually put it in my witness statement, and I think you provided further papers. And I think Mr. Jenkins actually was nice to put, nice to meet you and all the rest of it. Then I started remembering there was a conference. As to how that came about or what the circumstances were, I couldn't tell you. But certainly, I mean, we got a very experienced counsel who's been dealing with not just the post office cases, but wide experience of the prosecution for the CPS. He would have been well aware, and he would have made me well aware as to what I needed to do, as well as his duties. And I think he must have either the specifics of him being, his duties, my duties. We would have done that, but
I think it's right that there's no documentary record to which you can point that confirms that Mr. Jenkins understood, to your understanding, any relevant expert duties that he owed to the court. Is that right?
Well, it follows because, as I say, he didn't. He was never instructed as an agent from the outset, as an expert. Sorry. I'm trying to think at the same time as because his speciality was or his expertise was very, very specific, very specialist, and that was the special tailor-made system for the post office. Which
Well, he said it there. We had him for his expertise, but not as an expert, even though the thing we're asking him about is the thing that he's got expertise in. Really?
his employer provided for the post office. So he wasn't. I think that's where we were. That's where we were confused.
What were you confused about?
Confused as to whether he came as an expert or as a fact, because he was basically, literally assisting the defence expert.
Surely it's up for the prosecutor to decide whether somebody's an expert or not, hence why there's all those regulations, all the things to check and all the things to include in the statement. It's not up to Fujitsu, I would presume. A lawyer, please correct me in the comments if I'm wrong. It's not up for a company or the individual to say, I'm an expert. They could put forward the fact that they're an expert, but surely the fact of whether they are put forward as an expert witness and therefore have the duties explained to them is up to the prosecutor, because the duty on the prosecutor is to explain the requirements to them. So it must be the prosecutor, therefore, that determines whether or not they are being instructed as an expert or not.
The defence expert was not an expert on the Horizon system, if I can put it that way.
Did you feel confused at the time?
I don't know. I mean, I wasn't confused in the sense I think you mean. Certainly, I'm not, like I said to you, in this particular circumstances or in this particular incident, I've never instructed an expert for the post office in these incident. So I was new to it in that sense, because it wasn't second nature. If you've been dealing with something, on a regular basis, you would have everything in place. I would have had to basically start from scratch and work out the particular terms or the law, so to speak, as to my duty of the expert, because I don't think anybody within the criminal law team had he actually instructed an expert in that sense.